Coming in March of next year, family dispute resolution professionals. You will find the definition in the definition provision at tab 3, page 3.9 of your materials. I think it is to be particularly noted that we, a lawyer advising a party in relation to a family law dispute, is third on the list, and it's not even alphabetical. First are family justice counselors, next are parenting coordinators, and then lawyer advising a party in relation to a family dispute, mediators, arbitrators, and a person within a class of prescribed persons. I have no idea who that may be or will become. The definition is in keeping with the overall theme of the Family Law Act to reduce and lessen the emphasis of litigation in family law disputes. From my point of view, that's really interesting, because when I advise clients, I often tell them the basis upon which any lawyer advises a client is our best guess as to what a court would do with the facts that are in front of you. We have had the considerable advantage of almost a quarter century of judicial interpretation of the Family Relations Act. So hopefully your guesses are very good, and hopefully your friend on the other side has the same general guess and you're able to resolve matters. What we will have come March are the bare words of the statute together with what the government intends the section to do. So there we are. Interesting times may you live in. Is it a curse or is it a blessing? We'll think about that today. Ours is not to wonder why any longer, although I do hear on the street that there are some amendments in the works. Ours is just to do or die, so let's get on with it.
So the new legislation emphasizes out-of-court dispute resolution. It gives equal emphasis to agreements and court orders. And it, as I say, is accompanied by language as well as the subtext, which is the explanation by the government that is in the annotations that you're getting today, which is an earnest desire for that to occur. So the question is, will it in fact occur? Does the Act in fact push us in that direction? I say it will. I say it will move us to that, and I say that in fact we're going there already. So to some extent, what we have is the Act catching up with process that's already in place, and to some extent the Act leading that. And the way that it does it is in terms of the way the Act is set up. For those of you who are both mediators and family law lawyers, how does this change your practice? One of the interesting statistics that I learned about in the last little while is that there are 6,000 lawyers who are listed with the Law Society as having qualified to be mediators. And as you know, the current requirement is 40 hours of mediation training, 3 years of practice, and a couple of small incidental other things. 6,000 of you have qualified for that. Contrasted against that, there is a Mediate BC mediator roster, and the family roster has 43 members on it. So what's happening between the 6,000 so-called qualified mediators and the 43 roster mediators? Is that because once you're trained as mediators, you don't want to do mediation? Is it because, in fact, we have not yet achieved the critical mass of mediations being the go-to remedy that I think the legislators are hoping? Or is it a combination of people who are doing mediations not bothering with the roster because the hurdles that the roster requires are perhaps too high? They require actual experience, a number of hours in terms of mediation. So one of the things that I think we have to do as a profession is probably market what we do as lawyer mediators a teeny bit, and put forward how we add value to the process by virtue of our training. Now, the Law Society may or may not have helped us in that regard, because it has just come out with recommendations for a different hurdle in order to qualify for mediators. And that different hurdle now doubles the number of hours that you need to do by way of course load from 40 to 80 hours before you can qualify. And it adds 14 hours of approved training and screening for family violence. It does decrease the number of years you have to have practiced to 0 before you can become a family law mediator. And I suspect that the reason that's the case is very few clients are going to select a mediator that has no experience as a lawyer, and so the market will probably deal with that issue. But we, as grandparented mediators, those of you 6,000, will now have essentially a year to establish that you have done or will do the additional 40 hours and do the 14 hours. I don't know who's going to provide the 14-hour courses, and I don't know what the requirements are. Apparently, that will come. So there will be information that will be provided to you as to how that's done. There will be a deluge of people attending those courses, I suspect.
We have had some talk about jargon, and of course I read the legislation the way I wanted to, and I came up with the fact that we were family law resolution professionals, and that worked out to be a FLRP. And I thought that was a pretty good description, and I'm still sticking with it because I think that I don't think we should lose sight of law in ADR. I think it's still an important process. So I'm sticking with FLRP. I am aware of this apparent policy intention that this new Family Law Act is going to make family law more accessible to all, and that we now have all these fabulous tools for doing it, and nobody will have to go to court anymore. But of course, the big difference in arbitration is that the judge is free and the arbitrator is not. And I think that is something that we have to recognize. I don't see that it's necessarily going to cost anybody any less to go to an arbitration, except insofar as you can just build a process that may be faster and therefore be more efficient. But you have to pay the arbitrator, there's no question about that. I hope. And the other point, and I'm not sure what this is going to mean, except perhaps in parenting issues, is that the arbitrator in the arbitration process are, of course, creatures of statute. There's no inherent jurisdiction. But having said that, there are, I think, some really clear advantages to arbitration. The big one would be flexibility. As I indicated, the parties can define and design their own project, their own process. Again, this will be subject to regulations that we haven't seen, but that certainly has always been a hallmark of commercial arbitrations. Timing is another advantage. I think you'll be able to do it, determine the times, any time of day, really, subject to the desires of the clients and the arbitrator. I think another benefit that can be recognized is that if you go to a family law arbitrator, you're actually going to get somebody who has some interest and experience in family law. I think probably all of us as lawyers, and with due respect to the members of the judiciary who are here, we've all had the experience of a really strong feeling coming down from the bench that they would sooner be anywhere but in the courtroom dealing with somebody's ear piercings. And so the benefit of having an arbitrator is that that's going to be somebody who actually understands that, you know, whether the ears get pierced or you pick the kid up an hour later or an hour earlier is something of significance. I actually had a judge say to me once, you know, Ms. Henderson, you should settle this because I could be doing a criminal jury trial, and instead I am in the swamp of family law. True story. That won't happen if you get a family law arbitrator. And nothing is too small for the family law arbitrator to be interested in. And of course, there's also the question of more privacy if it's done through arbitration. You can also expect, I think, timeliness in the making of the award from the arbitrator, and location. The arbitrator can go to the clients. It doesn't have to be in a courtroom. And I think the experience we had in the distance mediation project would also suggest that there's no reason really why you couldn't have distance arbitration in circumstances where it became impossible for everybody to get together.